Hey y'all, Knox here with the American Suppressor Association, and welcome to the May 2025 Suppressor Policy Update. We are coming to you early this month because we have some of the biggest news in suppressor history. For the first time ever, legislation removing suppressors from the National Firearms Act has been passed by a chamber of Congress. More on that to come, but we've also got updates on litigation in Illinois, state-level legislation, and of course, wait times, so let's dive in. On May 22nd, the U.S. House of Representatives passed the One Big Beautiful Bill, including a provision that removes suppressors from the National Firearms Act. The removal of suppressors from the unconstitutional NFA tax scheme is long overdue and represents the biggest legislative victory for the Second Amendment community in my lifetime. It will benefit millions of law-abiding gun owners who simply want to protect their hearing while exercising their Second Amendment rights. Congressional Republicans are clearly keeping their promise to strengthen the Second Amendment and recognize the real need for these critical hearing safety devices. Special thanks to Speaker Johnson, Majority Leader Scalise, Majority Whip Emmer, Representative Ben Cline, and Representative Andrew Clyde for prioritizing the inclusion of Section 2 of the Hearing Protection Act in the House's reconciliation package. The day before its passage, the American Suppressor Association led a coalition of nearly 40 organizations, including medical professionals, Second Amendment advocacy organizations, and industry leaders in a letter to Congress urging them to include the full removal of suppressors from the National Firearms Act. Groups like the Academy of Doctors of Audiology and Doctors for Responsible Gun Ownership joined ASA, the National Rifle Association, Gun Owners of America, the Second Amendment Foundation, Safari Club International, National Association of Sporting Goods Wholesalers, Citizens Committee for the Right to Keep and Bear Arms, and the Firearms Regulatory Accountability Coalition, showcasing a massive united front on this issue. I want to take a step back for a second to highlight this point. I've been a professional Second Amendment lobbyist for 14 years, and in all my time, I have never seen the Second Amendment community come together like this. Our organizations, alongside the tens of thousands of people like you who called and emailed your elected officials, sent a crystal clear message to Congress. We will not stand for anything short of the full removal of suppressors from the NFA. That, ladies and gentlemen, is how we won this fight. We stuck together and we pushed our common cause, and Congress listened. If our community can continue to stick together like this, frankly, the sky's the limit. Passage of this legislation is a crucial step towards expanding our Second Amendment rights in our country, but the fight isn't over yet. The One Big Beautiful Bill now moves to the U.S. Senate, where we are already working to ensure Section 2 stays in. To do so, it must pass what's known as the Byrd Bath. The Byrd Rule isn't named after something that flies or anything with wings. It's named after Senator Robert Byrd, the Democrat from West Virginia who served in the Senate for over 51 years. A stickler for the rules, he noticed that the Budget Act of 1974 allowed senators to sidestep filibusters through the budget reconciliation process, which only requires a simple majority in the Senate. By the mid-1980s, Senator Byrd convinced 96 of his colleagues to support an amendment known as the Byrd Rule that requires senators to show that any provisions included in the budget reconciliation process are linked to the budget. In other words, they must be fiscal in nature and deal with taxes. Any provisions that are contested as part of the process are sent to the Senate parliamentarian, to whom Senate offices make their case as to why their provisions are germane. After hearing arguments, the parliamentarian makes a decision. This process is known colloquially as the Byrd Bath. To put it simply, the removal of suppressors from the NFA is Byrd Rule compliant because it changes the tax code and therefore impacts the budget. In other words, it is both fiscal in nature and deals with taxes. At the end of the day, the National Firearms Act is just a tax scheme. In fact, the entirety of the NFA statute exists in the Internal Revenue Code. When it became law in 1934, Congress justified the NFA as a revenue-generating measure. The National Firearms Registration and Transfer Record exists solely as a registry of NFA taxes paid. Getting the theme? In 1937, the Supreme Court even upheld the NFA as a revenue-generating measure in Szynski v. U.S. So to anyone saying that removing suppressors from the NFA is policy and not germane to the reconciliation process, hit them with the facts. If eliminating a tax isn't germane to reconciliation, I certainly don't know what is. Now that the One Big Beautiful Bill is heading to the Senate, we need your help to make sure that your senators know that removing suppressors from the NFA is a top priority for you, their constituents. Visit hearingprotectionact.com. That's hearingprotectionact.com right now to email your senators. It's simple and easy and takes about 25 seconds to complete. Every email and every call matters, so make your voice heard today. In the meantime, we will continue to work alongside our partners to ensure that the Senate keeps Section 2 of the Hearing Protection Act in reconciliation. With your help, let's get this one big, beautiful bill to President Trump's desk, and let's get cans out of the NFA. For now, suppressors are still in the National Firearms Act, so let's talk wait times. According to ATF, for the month of March, E-Form 4s averaged 10 days for individuals and 16 days for trusts. Fast forward to April, and those averages dropped to 9 days for individuals and 10 days for trusts, with a median processing time of just 4 days. As of May 23rd, the median wait time for silencer shop customers is 7 days for individuals and 15 days for trusts. Now, I sincerely hope this is one of the last months we ever have to talk about wait times, because if suppressors are removed from the NFA through the reconciliation, wait times will be a thing of the past. Remember, go to hearingprotectionact.com to let your elected officials know that you want suppressors removed from the NFA. At the American Suppressor Association, we believe suppressors should be legal in all 50 states. Over the years, we've helped enact dozens of pro-suppressor laws across the country, but we still have more work left to do. This month, pro-suppressor bills were heard in 2 states. In Massachusetts, H. 1700 was taken up in the Joint Committee on the Judiciary. Sponsored by Representative Paul Frost, H. 1700 seeks to make suppressors legal in the Commonwealth. It was unfortunately tabled for further research and is unlikely to move. And in New York, Senator Robert Ort's S. 2099 was heard and defeated in the Environmental Conservation Committee on May 13th. Like Representative Frost's legislation in Massachusetts, S. 2099 also sought to legalize suppressors, this time in New York. We applaud these two for fighting on behalf of law-abiding gun owners in their states, and will do everything we can to help make suppressors legal in all 50 states. Right now, we believe the best chance we have to win is through litigation. On April 30th, we saw the first movement in Byrd Rule that we've seen in quite some time. Unfortunately, things didn't move very far. Byrd Rule is the ASA Foundation and silencer shop backed lawsuit challenging Illinois' ban on suppressors. On the 30th, Judge Dugan held a hearing to address the state of Illinois' motion for judgment on the pleadings. He seemed open to our arguments and asked the other side some very tough questions, but at the end, he indicated that it might be quite some time before he issues an opinion. So, we find ourselves in another holding pattern. Here's to hoping things shake loose very soon. Without dollars and cents, the American Suppressor Association would not be able to fight for your suppressor rights. In May, Rugged Suppressors committed $40,000 towards ASA's efforts. Their contribution directly supports our work on Capitol Hill to remove suppressors from the NFA. Michael Derdziak, Henry Graham, and their team understands what's at stake, and they continue to lead by example. With their partnership, we're able to push harder, go further, and stay focused on meaningful policy change. So to Michael, Henry, and everyone at Rugged Suppressors, thank you for your support. We would not be where we are without you. Well, May has been one heck of a month. If you like what we're doing and want to support our work, click the link below or visit us at asamember.com. That's asamember.com to join or donate to ASA today. And remember to contact your legislators at hearingprotectionact.com. That's hearingprotectionact.com. As always, thank you so much for tuning in. We will see you next time.